this hour. I'm Dave Anthony, and this is Fox News.
Lawrence County depends on WDXE News. On the air since 1951. This is The Legend. 105.3, 95.3, WDXE.
And it's time for Bulletproof Estate Planning with my friend Stan Pierchoski. How are you, buddy?
Good morning, Jeff. I'm fine.
It's Friday again.
And we are. When we are the legend.
We are the legend, that's right.
It is Friday again, and I don't know, I'm sort of happy to see Friday come this week. Normally it goes fast and just kind of gets here, but I just was sort of in the mood for it to be, I don't know, I think it's maybe the cold.
Yeah.
It is cold.
It is cold. I think it's about 30 degrees out there right now, so yeah.
I mean, I went to bed last night, it was 20, and I got up, it was 24, so that's not usual, but it must be warming up the rain.
Warming up it's supposed to rain this afternoon, I think, or early evening.
I saw that,
We'll see. And I think my little forecaster had some little mix of snow maybe, so I don't know if we would get that or not.
In places, I guess.
In places it will.
Anyway.
We'd take it. It'll be okay.
Oh yeah.
It'll be okay.
I mean, after all, it is January.
It is January.
You know, we sort of can't take the position, how dare it get cold in January.
Yeah. I had Daniel go out and check my cows yesterday. We've got some cows that's supposed to be calving in the next 2 months or so.
Oh, you get cattle?
Yeah, well, a few. We don't have many. Just pets mainly.
Pets, yeah.
Just pretty much pet cattle. But he takes care of them, Daniel does, so that works out pretty good.
Reminds me of an old joke where somebody had a cow and somebody stopped by who had a flat tire and sees his cow and he said, "That's a nice looking cow," but the cow had an artificial leg. And he said, "Why does that cow have a wooden leg?" The guy says, "You got a cow that nice, you only eat them a little bit at a time."
That's right. That's right.
It was actually a pig in the joke. But
there was a pig, yeah. That's all right.
All right, so this is Bulletproof Estate Planning. We do it every Friday from 8 to 9 on this radio station. It is a interactive show, talk show. Got something you want to ask or share that has to do with estate planning, call in. Telephone number 931-766-9393.
That is correct.
I'm not a radio announcer, so I say it nice and slow so you can actually have time to write it down. So 766-9393, give us a call. What's coming up? You can go to my website and read some of the stuff we put on there. My website is slowly getting revamped. It just takes a while to do some of that stuff, but we like to keep the blog material and the reading material on it up to date.
Yeah.
They're doing that, but that website is PierchoskiEstatelaw.com, but if you want to get there easily without trying to spell my name, it's just Estate Plan Stan. And
that's right.
That'll take you right to it.
That's perfect.
And you can get the phone number there, you can have an email, you can ask a question that way if you want me to respond in writing, and I will. Will it be timely? Pretty much so, but will I answer it? Absolutely.
Yeah.
Just depends on when it comes in and what's going on, but those questions, especially in phone questions too, the gals will take the messages and the emails and they'll print them off and they'll bring them to me. We have a little system. They'll bring them to me and they'll schedule a callback. Now emails they bring to me, and if I haven't answered them within a day, they remind me that I haven't done that. So, but I answer all that stuff. So anyway, a lot of other good reading on the website. Plus, you can look at my calendar and see where I'm going to be. And I'm going to be at a seminar, which is going to be the 24th, which is a week from tomorrow. And that is going to be on the square in downtown Pulaski at the Star Theater. And we got a pretty good RSVP list going for that one. So called Will's Trust in the Nursing Home, and that's what we talk about. It's about an hour to 15 minutes long. It is a pretty involved question and answer period afterward.
Yeah.
And if you're thinking about this stuff, you want to get some insight.
Sure.
Because you will hear, I guarantee you will hear things that you're not used to hearing or haven't even heard at all before. Now, if you listen to the show, you might have heard me discuss some of those concepts, but there's a lot of options out there for estate planning.
Yeah.
It's not just a will or nothing at all. It's not that simple. There's other options, and I think there are other better options, way better options than a will. Now, if you got a will, I'm not saying it's bad. A will's a step in the right direction, but a will has a lot of limitations to it that don't really thrill me, but especially when the options out there like a trust plan, the things you can do with a trust plan, the things that you can avoid with a trust plan.
Right.
And I think there are just better options. So we talk about that. And if you hear things you haven't heard of before, just be open to it. Every now and then I'll get somebody that says, "Well, I've never heard of that, so I don't see how that can be." It's like, well, there can be something out there you haven't heard of. So have an open mind.
Yeah.
And most people do. Most people that come have already been thinking about this.
Sure.
Let's face it, people don't stand in line to come to a estate
Sure.
planning seminar, right? But if you have been talking about this with your spouse or something, the family, you're thinking about it,
Right.
or a lot of times what happens to folks is something happens to somebody they know in the community or something, and it just brings it to the front of your thought, and you think, we need to do something about that.
Yeah.
And if you procrastinate, don't feel bad. I mean, I get this all the time. People say, we've been talking about this for 4 years. This was a signing week for us. We did several trusts and had one this week where the couple said, we've been talking about this for 4 years. And so we finally got it done. And we said, we need to do it. We want to do it. I don't know how to do it. What should we do? When should we do it? We need to do it now. And finally they did it. And they were very happy that they got it done. But my point is, don't feel bad if you're in that boat. Because I'm going to tell you a story that I guess could be somewhat embarrassing for myself, but everybody does.
Yeah.
They do. You're not the only one that's procrastinating. If that's the
Oh,
case.
yeah.
And the story I like to, I don't like to tell, but the story I'll tell is, I started practicing law. It was a second career for me, but I started practicing in 2003.
Yeah.
I was an engineer for 20 years before that. But when I put up my shingle and became an attorney, I started I passed the bar in 2002, and then January 1st I put up my sign.
Right.
And I was practicing law for 7 years, so that puts me somewhere around 2010, before I wrote a will for my wife and I. Now that's pretty embarrassing. No, but it gets worse. It gets worse. We wrote this will about 8 or 9 o'clock at night, on the night before my wife and I went on a Caribbean vacation where we left our 3 minor children with grandma.
Yeah.
And so we squeaked right under the wire, right?
Oh, my.
So don't feel bad. Everybody procrastinates. You're in good company.
Well.
So that's a embarrassing story that you think somebody like me would be on top of that. But I wasn't practicing state law back then. But
Yes.
still, I
Yeah.
knew about it. And so don't feel bad. But if you want to talk about it, come to the seminar. Another thing about these seminars, there's like no pressure. I mean,
And there's no charge.
no, there's no cost. And you know how sometimes you get something in the mail, and I'm not bashing this at all, but you get something in the mail that say, meet us at the restaurant, we'll give you a free dinner. I mean, I've been to those, it's been years and years, but I've been to 1 or 2, and there's definitely a sales pitch there. You know what I mean? And you don't get much about the product, you just kind of get the sales pitch. Okay?
Yeah.
And now that's a marketing technique. It's just not one of my favorites. I don't do that. You can come to a seminar. We don't give you a meal. We'll have some light refreshments.
Yeah.
My wife makes these blueberry muffins, and I have some people that even years after comment on those blueberry muffins.
Yeah.
they are very good. But anyway. Come to the seminar. We have, like I said, light refreshments. We talk about stuff. You're welcome to listen to it. And if you want to get up in the middle of it and walk out, I'm not going to stop you. It's not like I lock the door and make you sign something.
Sure.
We don't commit to anything. I just don't do it that way. What I like to do is give you your options, because when we were just talking about procrastination, I think the reason I procrastinate on any issue is because I don't feel comfortable about the path forward. I don't know. You know what I mean?
Yeah.
But once you hear all the options about estate planning, it's like, well, I guess I'll do a will, but I think that's all I can do. But and then you hear these other options, and you start to think, wow, some of these things are better for my family than this.
Sure.
And there's several options, so most people kind of hone in on one that fits their circumstances or their family dynamics. And then they start feeling more comfortable. That sounds like a good solution to me. And once you start reaching a point where you say, well, that sounds like the one that fits me the most, the procrastination kind of goes away. Now you sort of have a path forward that you're going to do. And I think that has a lot to do it.
Yeah.
Like I say, you want to invest some money in the stock market. You're going to him and haw, should I do this or should I do that? Oh, that was going down. I don't want that. Or this was going up. Oh, no, turn around. And you can't. It's hard because you just don't have enough information to move forward.
Sure.
And I think it's subconscious. You don't really think that that's the reason. You just don't do it.
Yeah.
And so when you come to the seminar, I find it fills people with the information they need to know, and it makes them comfortable going forward. And I get great reviews from my clients for one thing, getting it taken care of. One, it being so thorough. We do stuff very, very comprehensive, and I make it so they understand it. I talk about these trusts at the seminar. I talk about them at the vision meetings that we have afterward, and we do a deep dive into this stuff. I want you to understand what's happening. Now, it's not a law class, but it's enough discussion for you to understand what a trust is and how it works and how it will work for you. And I want my clients to be involved in the decision that says, yes, that's for me.
Sure.
I don't, a lot of attorneys get accused of telling clients what they need.
Yeah.
And I don't do that. I probably did back when, but I don't do it. I don't do it in this matter of law. I just kind of present these options and say, which one looks good? If they say, well, this is what this, and of course, our asset protection trust is very popular, and people say,
Yeah.
I like that because I don't want to lose everything I've worked for all my life to the government. And
Right.
so then when I feel like we're leaning one way or the other, we'll do a deep dive into that particular one because there's several
Sure.
different options there. Have their own little specifics and things that are
Right.
different. So
Right.
then I got a whiteboard in the office and I draw diagrams. We talk about it, and it's just the way I do it because, like I said, I don't want to say, hey, you need a trust, sign here. Don't worry about what it says. I've already thought that out for you.
Yeah.
I don't. I want you involved in the process, and when you're involved in the process, then you have a level of understanding of what's going on, and you feel comfortable.
I was going to say, it certainly brings about a comfort level to what you're doing.
And this doesn't happen often, but if it's what we talk about is just not for you,
Yeah.
then that's okay. That is okay, and it's okay because of this. It's an informed decision.
Right.
A decision is a decision, but it's not good or bad unless you're just winging it.
Yeah.
But once you get the information, if you might just say, that's just not for me or my family. That's okay. Say no. I mean, stick around if you want to have another muffin or something. We'll still be friends. I get it. Now, the majority of people like to do something, but
Yeah.
I'm just saying that's a decision too, and it's okay.
Yeah.
If that's an informed decision, then it has to be respected.
Sure.
Because every now and then I get somebody to say, well, I'll be gone and I'll just let the kids fight over everything. It's like, well, if that's your position.
I can tell you from personal experience and dealing with that with folks and families, that is a terrible idea.
It is, but I mean, if that's your decision, then if that's your decision, there's nothing I do that will be of benefit to you.
Yeah.
Because when you do this kind of estate planning, you pretty much do it for the people you care for.
Yeah,
For your loved
exactly.
ones.
Yeah.
A lot of it, I mean, like asset protection, of course, you do it for yourself, but you also do
Yeah.
it so that your estate doesn't get bled dry, and there's nothing to go to the subsequent generations.
Yeah.
So you are doing it for them as well.
Yep.
So anyway, so that, like I said, in the next seminar, I'll bring it up again at the end of the hour, but 24th over at Star Theater.
24th, the Star Theater, and that's on the square in
Right.
Pulaski.
Right on the square.
And you start at 10 a.m., right?
10 a.m. on Saturdays, that's right. It's called Will's Trust Lenders. Now,
All right.
speaking of the square in Pulaski,
Yes.
I'm not beside the theater anymore.
That's right, you're
We
not.
moved. I said I had enough. I'm packing up and moving. But then I only moved 2 blocks away. Actually, when you're at my office, if you could see through the courthouse, you could see where we moved to.
Okay,
it's
great.
It's kitty corner and 1 block down. So
Yeah.
anyway,
Good deal.
so we're there. The signage isn't even up yet. It's due next week. But we spent this whole week was our first week in full operation at the new
Yeah.
new place. So
Yeah,
we're happy
very
with
good.
it.
Very, very good. It is 8:19, and of course, we are live here on WDXE. Got a call coming in, one of our regulars.
I didn't hear it ring. So
Well, I've got the ringer turned down, so
Okay.
I just have to watch for the lights here. All right, Peggy, what you got on your mind this morning?
Yes, he covered something last week, and I've only been listening to him for a little over a year. I think it started like in November or December, and I think he said he had covered this before, but I hadn't remembered it. It was about somebody that had inherited property, and they did not know yet whether or not it was in a trust. They've got an appointment in a couple of weeks somewhere to talk to somebody. And was that the pour-over in Tennessee? Is that not the trust? The will he recommended where if you inherited something outside a trust, that you could do a will where you could put it in the trust. And I'm going to stay online because I've got a second question regarding this.
Okay, let's get our players straight. The beneficiary does not, the person that inherits would never use a pour-over will, because once they inherit it, they own it. Now, they can certainly write a will where they want it to go at their death. But there is such a thing as a pour-over will, and that is part of a trust plan. So, Jeff, if you did a trust plan, you'd have a trust, you have a lot of supporting documents for that trust. One of them is a pour-over will. It is a last will and testament, but it's a special kind of pour-over will because it's not like a will like you think. It's not a will that says I leave this to my wife, I leave this to my 3 kids, I leave this to my buddy Stan, stuff like that. It says, hey, I have this trust, and if there's anything I did not put into the trust, this wills it to the trust at my death. So there's only one beneficiary to a pour-over will, and that is your trust. So the pour-over will is for the maker of the trust, that plan. So if you inherit something if you have a trust plan, the beneficiary kind of can't inherit it outside the trust because let's take a piece of real estate. If it's deeded to the individual or the couple at death, the poor of a will catches it, sends it to the trust, and then the trust distributes it to the beneficiary.
Okay, that makes sense.
Does that help?
That makes sense.
Okay, let's say someone found out after the fact, and I don't know, this is in another state, but they didn't necessarily have that in trust. If they did have a poor will and it wasn't done originally with the trust, could it be done later? And secondly, is it subject to probate if it happens a different way? Anything you discuss along that line is okay, but don't spend a lot of time. I'm just trying to figure out something to discuss with somebody. Thank you.
Sure. Well,
Thank you, Peggy.
if you have something like a revocable living trust, the theory is you really want to put everything you own into the trust, because if everything you own is in the trust, then all your property will pass probate free to the beneficiaries of the trust.
Right.
So the poor of will actually has language that says something like this: hey, I've got a revocable living trust. I funded my revocable living trust. It was my intention to put everything I own into this living trust. However, if there's anything I've forgotten, neglected, or otherwise overlooked,
Yes.
I will it to the trust. Okay, it's called a pour over will. Pour dash over, over, pour over, and that's what it pours what's not in the trust. It catches it and pours it into the trust. That's the way
Yes,
to think of it.
right.
If you need a visual.
Yeah.
And so the first question she said, it can't happen if you're a beneficiary and you have property coming to you because and the person's trust plan did not have a pour over will. Then that does go through probate. The pour over will is a probate action, but it can be it usually can utilize one of our versions, our abbreviated versions of probate.
Sure.
If that happens, if it's like real estate, we have muniment of title. If it's not, if it's something else, we have affidavit of heirship. So there are ways we can transfer property, quick proceeding. So the pour over will, I always tell folks, plan A is put everything into the trust, okay? And then the pour over will is just a waste of paper and a waste of ink because it's all dressed up and no place to go because the will can only transfer property titled in your individual name. And if you put everything in the trust, it's all titled to you as the trustee of the trust.
Sure.
So there's nothing for it to pass. And that's plan A. Make it so it doesn't do anything. However, plan B is if something slips through the crack, and this happens relatively often, this will catch it. It's like a safety net. It's plan B. It'll catch it and send it to the will. That is a probate action when we do that, though.
Sure.
Because it's
Okay.
a will. Because all wills go through probate. But it's usually a single asset that got overlooked. And that, when you have a single asset in probate, you can speed it up faster than the normal 12 to 16 months of probate.
Yeah. Interesting.
So,
Very interesting. That's
let's see
a
what-
good. That's a good little thought. I mean, that's a good line of question there. That's all right.
and it's a little bit different in the asset protection trust because the asset protection trust, we cannot put everything into it. Because if we put everything into it and we have this restriction of access to principal, then you've made yourself insolvent. And we don't want to use that. Remember, well, if I had a diagram, the back door where we can actually get property out by giving it to one of the children who
Yeah.
can turn around and use it on our behalf, right?
Right.
So we don't put things in there like your checking account, things that you are invading the principal on a regular basis. Because if you did, you have to use that back door every time. It's too cumbersome.
Right.
So we keep the stuff we're living off of out. So there the pour over will is just ever so slightly different language. It pretty much says, hey, we have this asset protection trust. We know we can't put everything into it. So it recognizes that we know at death there's going to be things that are not in it.
Yeah.
So those things go to the will at death. And then, because what I like is I want the trust instrument to control all the distribution. So I want it to end up in the trust. When some of it just gets there, it just doesn't get there till death.
So when you do a asset protection trust, you normally still do a pour over
Yes.
will.
But we try to do the same thing and avoid using a pour over will. So let's say you do an asset protection trust.
Yeah.
And everything you put your house in, maybe you have this investment account that you're not living off of, and you put that in, and now you have a checking account.
Yeah.
And you write checks on it every month.
Yeah.
10, 15, 20 checks every month. We don't put that in, so it stays out. Now, if you pass away and you have, $20,000 in this checking account, the pour over will would catch it and send it to the trust. But in order to avoid even that little bit of probate, what we would recommend is, hey, have one of your children as either a co-owner on the account, which is my first choice is have one of the children pay on death on the account,
Yeah.
or make them a co-owner. Co-owner is not my favorite, but it will work. And those are probate avoidance techniques. Now that account will not go through probate, because if you make a pay on death to somebody, it's going to somebody. And you can make the pay on death the trust. So it ends up in the trust and never went through probate, because it's beneficiary driven now.
Okay, is that action in the trust, or do you have to do that with the account at the bank?
With the account at the bank.
Okay, so that's the way the account is set up.
You go to the thing, hey, I want to put a pay on death on this account.
Okay.
Which is a beneficiary.
Right.
Okay. And so at death, now, the only issue with that I might, if you say, you have 3 children, right?
Yes.
What's the name of the boy that's always in here?
Daniel.
Daniel. Okay, so you go to the bank and you say, I want to make this bank account pay on death to Daniel, because when I pass away, I want to make sure it doesn't go through probate. It goes to Daniel by contract.
Okay.
That you have with the bank, right?
Okay.
But at your death, that $20,000 is Daniel's. And
Yeah.
maybe your intent was to have all 3 kids have a third, right?
Right, okay.
So what you can do, though, instead of go to say, hey, I want to make this bank account pay on death, and the bank says, who do you want the beneficiary to be? Say, I want it to be Jeff's trust. Because then, so at death, it goes to the trust, probate free, because it's a beneficiary, and the trust then distributes it a third, so you can get that proper distribution.
Now, so there's a,
And even though you had something not in the trust, and you had a pour-over will, we never used a pour-over will, and we never set 1 foot into the courthouse to be in probate.
this just struck me funny. Where there's a will, there's a way.
There you go. Yeah.
So
I
anyway.
like that. I may ask permission to use that.
You can have permission.
I'm not sure
it's
I'm not sure that was an original.
It's not.
Although it might be if your
In
will,
this application, it may
It
be.
might be if your will was with a capital W.
Yeah.
That might be you might have come up with that one. Good, I like that.
That's funny.
So I mean, it's a little deep, the concept, but I try to paint a picture so you can see what's happening. Something like that.
Very interesting, though.
But these are all things we think
A
about.
lot of good thought in there. I mean, that makes me think every time we talk.
The whole plan's got a lot of supporting documents, and it's this kind of stuff. You know,
Yeah.
it gives you powers during life. These are the power of attorneys, because when you name somebody as a power of attorney, that doesn't survive death, that power.
Yeah.
I mean, there's a way to make it, but we don't do that. But I'm just saying it pretty much expires at death. That's the incapacity planning we do. We think, well,
Yeah.
what if you become incapacitated?
Yeah.
You know, where some people say, well, you become incapacitated and die. Well, not everybody becomes incapacitated.
Right.
We all die. We all get the same end result, but some of us don't become incapacitated. And the incapacitation I'm talking about is not a coma or anything.
Right.
I mean, you could be cognitively impaired where you just can't make decisions. You know,
Right.
dementia.
Right.
So anyway.
Well, I have an asset question.
Okay.
It just struck me because I mentioned earlier that we have a handful of cattle. They're just
That's an asset.
They are an asset. So are they handleable in what we're talking about? I mean, can you assign them at death, or is that because throughout maybe owning cattle, you have a lot of coming and going. We're buying and selling. We got calves. They're growing up. So there's a herd of
It's a moving target.
15 or 20 now. Then there's maybe 30 next year. Maybe not that. Maybe the next.
It's a moving target.
It's a moving target.
Yeah. Well, let's go to fundamentals and nuke it out.
Okay, nuke it out.
Cattle are personal property.
Personal
Let
property.
me back up even further. There's only 2 kinds of property in all the world.
That's right.
One is real property, which is land and anything permanently attached to it.
That's right.
Cows are not that definition. Everything else is personal property.
Yeah.
Everything. Okay. So they're personal property, and when we have a trust, we can put our personal property in the revocable living trust. You can put personal property in any trust.
Okay.
Some trusts we don't, but I'm just saying you put it in a trust. Or let's say you don't have a trust, you want to write a will.
Yeah.
You can, I have done specific distributions for people where they'll say, all right, at my death, 50% of my cattle go to my daughter and 50% of them go to my son. Or
Yeah.
something like that. Or you can leave them all, you can just say, if you said, I leave everything, let's take yours and say you're very generic, nothing specific, everything I own, divide 3 ways to my kids.
Yeah.
What you're saying in there is when we get to the cattle, they get a third of it. Each
Okay.
kid gets a third of the cattle.
Okay.
Just like each kid, let's say you have a collection of something, part of your stuff.
Sure.
Like maybe you have a Beatles collection or something. They get a third of that. Really it's a third of everything.
Yeah.
But it doesn't break down to, if you have one single item, they don't get a third ownership of that.
Sure.
Personal property gets divvied up with a little more leeway, but you can specifically say cattle.
Yeah.
And I have people do that. sometimes you'll have something, a lot of people have cattle in this neck of the woods, right? I mean,
Yeah.
farms, family farms.
And they're high dollar stuff
They
right
can
now.
be, they sure
Yes.
can be. And I want to talk to you about that. Let's see if we can do something about the price of ribeyes.
Yeah, I'll see what I can do.
But they're, where was it? Oh, somebody might say, okay, my son works with me now on the farm, and
Yeah.
I'm going to kind of leave it to him because he's the only child here working on it. He's the one that's going to continue with it. The other
Yeah.
two have moved off somewhere, and they really don't have interest in the
Right.
farm. They just want to inherit money. Okay, so they'll say, okay, I leave the farm to Joey, the son, and I'm going to leave him all the cows. And
Yeah.
it usually goes further than that. So we're going to leave him all the tractors and all the stuff,
Yeah.
all the implements, hooked, all the stuff he needs to keep running the farm.
Right.
That's all personal property too.
Right.
And we leave all that to him. The money in the bank, and we're going to split up among the other two. As, that sort of thing.
Yeah.
That's very common. So cows, let's say you have something, some memorabilia you have that you want to leave to somebody.
Sure.
You just say what it is, who it goes to, and you can do that. Cows are in that same category.
Right.
You can say, the cow with the wooden leg, I want that to go to Daniel.
Yeah.
Just it should be as specific as you want, or in general
Yeah.
as you want.
That's interesting. It just struck me because I'm telling you, these a good mama cow right now is anywhere from $3,500 to $6,000 just
Yeah.
that one head. It's crazy, and that's the reason why you got a ribeye like.
Well, I'm of the opinion if it's not a ribeye, it's not a steak. I'm just a big fan of ribeyes. But
I love a ribeye, but I love a fillet too. It's just got to be
well,
ready
you
to
know
pay
what?
for it.
Sometimes we go to the Japanese restaurant.
Yeah. Yamato?
Yamato, yeah.
Yeah.
They have it's called L6, their lunch.
Yeah.
It's a lunch dish. It's a fillet. And I like it medium rare. And they
Yeah.
always do it just right every time. It's hard to get a steak the way you want it, especially if you lean on the rare side.
Yeah, I
You'd
like.
think that'd be easy because you don't cook it much, but
Yeah.
it's hard, But that fillet is very good.
Yeah, good deal.
But you know what I'm saying? I'm just a big fan of ribeyes, and I just wish they were a little easier on my cholesterol.
Yeah.
Red meat is. But anyway, no, I know a cattle. Depending on the market, they could be
Sure.
real high dollar, and
Sure.
then, and one thing, this is a little digressing a little bit, but when you're a farmer
Yeah.
and do agricultural stuff.
Yeah.
You got a cow, and it calves, right?
Yeah.
You have it a couple of years. So this one cow produces, I don't know how many other cows, right? So it's a pretty good investment over time. Right?
Over time, over time they kind of pay for themselves.
Same thing when you plant a crop like corn. Let's say you
Right.
plant corn. Well, when you harvest your corn, every stalk of corn has got, 5, 6 ears on it? Each ear's probably got 100 kernels in each corn. You have like 1,000% increase in corn seed. Not only do you have enough corn to plant for the next year, the other 90% you can sell for whatever you sell corn for.
Right.
So you plant a seed, you get a corn stalk, you get 1,000 more seeds. That's a 1,000% return on investment, right?
Supposed to be, yes.
That sounds like a deal only somebody like a lawyer could screw up, right? that is like God's promise. God's promise. You plant the seed, and you follow my
Yeah.
agricultural laws. The ways to treat the soil and stuff like that, and you'll be rewarded, and you
Yeah.
are. That is 1,000% increase.
Yeah.
Same thing with the cow. You have the cow or several cows. Maybe you got a dozen cows. In 2 years you've got 100. I'm not sure how it works, but you got a tremendous return on investment.
They'll have a calf a year.
And just one for one, but still,
Yeah.
if you have a dozen of them, you have a dozen more.
Yeah.
So technically,
Generally speaking.
I'm not speaking from experience. My neighbor has the cows, and I see all the running around he does, and I kind of figure out I wouldn't have time to do what he has to do. But he does well with it. He certainly makes a living.
Yeah.
And some people have gigantic herds of cows. Hundreds of cows.
Yeah. I'm not a super cattleman.
That's a
I'm
real
not.
business. That's a real business then.
It is. Now my auction partner, he's what I'd call a real cattleman. He has a couple hundred head maybe.
Yeah.
And that's a pretty big cattle operation.
That's a career. That's a full-time job when you get it like that. But
Yeah.
I'm not sure how. Okay, we got off on that, but it was the cows are personal property. You can leave it any way you
Well,
want.
one of the reasons is there's a lot of money to that's and when you pass, if you still have a herd of cattle, somebody's got to do something with them, or take care of them, or whatever. So I just wondered how that. My real question was, can they be assigned at death, like a bank account? And I didn't know how that would happen.
Well, it's kind of, but if you write a trust or will and you say in there, here's where the cows go, you're saying where they go at death.
Yeah. Okay.
It's A bank account is a contract with another
Right.
third party, which
Right.
you wouldn't have with cows.
Yeah, you wouldn't
And
have.
you might have it,
such-
maybe in your partnership agreement, you could put some, you could maybe something like that.
Yeah.
You could sign where your share of the cattle go.
Yeah.
You know, I mean, you don't have a partner with your farm, but if you and
Yeah.
somebody else were farming together, you could
Yeah.
do that.
Interesting.
But, you know, it's like, don't overthink it. It's personal property. It goes where, you either say where it goes, or if you don't say where it goes, it just passes like all other property. It just gets
Yeah.
divided among the children. And, you know, and it just gets divided in equal shares. But if you have no will or
Okay.
trust, they're just gonna, same laws of intestate succession will divide all your property and pass it around. And it'll just go by that. Even if you don't specifically say you have cows, it's property that you own.
Just like I said, Stan, where there's a will, there's a way. There you go.
You know, I don't want to digress again, but I used to teach some things. Okay, you know, back in basic law and stuff like that. And there's
Yeah.
When you're an interesting concept. People get upset sometimes when they get married and have children,
Yeah.
and then the state Tennessee
Yeah.
kind of tells them what they can do with their children,
Yeah.
and that upsets people, right?
Yes.
It certainly upsets me.
Sure.
And the wonder is, how do they get authority over a child to be able to do that? You know, and it really is an interesting concept. Well, it's not a good concept, but it's an interesting concept how they gain that authority. I'm not going to get into it, but you know, people in the United States end up as articles in commerce under the Commerce Clause.
Okay.
Because, I mean, if you don't believe me, go look at your birth certificate. What's it say at the top of it? It's going to say the Department of Commerce. And first question you might want to ask from a legal standpoint: why is the birth of my child
I have
in
never,
the Department of Commerce?
I've never read word for word my birth certificate, or anybody's for that matter.
So I used to tell people, I say, you know, if you're in the Department of Commerce, then you're under the umbrella of the United States Department of Commerce.
Interesting.
And commerce is controlled by Congress, right?
Why is this?
Because it's in the Constitution. Or why they put it under Commerce, that's a longer story. But I used to say, you got a farmer, and he's got a bull, and he's got a cow.
Yeah.
And the bull and the cow get together like bulls and cows do.
Yeah.
And the cow has a calf. A legal question arises. Who owns the calf? The cow? The bull? Or the farmer?
Well, for me, there's no question the farmer owns it.
Okay, well, you just have to extrapolate that and you kind of see where I'm going.
This is one of those things that a lawyer's going to screw up. So.
Anyway, we're getting off into a topic I do not want to discuss.
Okay.
But, so yeah, we solved the cow problem. So
Okay.
I think we answered all Miss Peggy's questions.
766-9393 if you want to talk to Stan about wills, trust, estate planning, and bulletproof estate planning especially. And the asset protection trust is quite a popular subject with you.
It is. As a matter of fact, the asset protection trust, when you put property in it, you're protecting property. And a lot of people want to protect it from the government, and the government they're referring to as long-term care through
Yeah.
the Bureau of Care, right?
Right.
And I mean, you can't protect it. Taxes are taxes. I mean, there's some tax advantages you can get, but you can't really put it in trust and expect to not pay tax on stuff.
Right.
I mean, that's a barrier. The government that way is a super creditor. I mean, it can pretty much invade anything.
Yeah.
You know, some people actually put property in foreign asset protection trusts, like in other jurisdictions. That gives me the creeps. I don't like doing that. It's
Would give me the
it's a
creeps,
whole
too.
other jurisdiction. But there's some wealthy people put a lot of money and stuff like that. But anyway, the asset protection trust, you put property into and you protect it from that, and you're really doing that way in advance of ever. And if you're doing it to keep it from the nursing home getting it someday, you're doing that way in advance of the nursing home or long-term care ever being in your life.
Right.
And so you're actually making yourself or taking certain property and making it eligible for long-term care way, way in advance. Because
Yeah.
when you put in the trust, we got a 5-year period we'd like to clear.
Yeah.
We'd like to get past that 5-year period if we can. And the 5-year period will start the day you put in the trust. So if you put in the trust earlier in life, the 5-year period is more statistically in the bag, so to speak.
Sure.
Of getting past it without having to.
Sure.
If you're advanced years, 89, and you already got issues and you put in the trust, now it's a little more of a wait and see approach. We don't.
Yeah.
Can you stay out of the nursing home for 60 months? I don't know. We'll just wait and see.
Yeah.
And so.
So earlier the better, really.
It is, and and there's my experience is, if you're somewhere in your, may say mid-50s to maybe even 70 or so, is a real good time frame, because if you do that, Well, for one thing, you don't care about long-term care before that.
That's true.
People's in their 30s, 40s, early 50s.
Yeah, you're not thinking about it.
They say, I'm not worried about that, I'll deal with that later. A whole lot like I said when I was in my
Yeah.
30s and 40s, I'm not worried about that, I'll deal with that later. But when you get to retirement age or approach retirement age, you start to think about this.
Yeah.
And it becomes up, comes to the forefront of your thought process, and you start thinking, gosh,
Right.
I'm retired or I'm about to retire, and that means I spent my whole life building my nest egg. Whatever that nest egg is, I spent my whole life building it. And my wife and I, heart, blood, sweat, and tears, whatever it took, and you have it, and you're thinking, yeah, one of us goes into care. I mean, the average right now is $10,000 a month. It's right at $330 a day. It really is either above or below, depending on whether it's 30 days or 31 days.
Yeah.
Now, I heard there's a change happening right now amongst an increase in cost, which comes as no surprise. It's not official yet, but I know of one facility that already raised their rate that I was dealing with, and they said our rates are going up in effective such and such a day, like sometime in February. So it's probably going to go across the board when they do that.
Yep.
I had 2 or 3 just in 2025. So it's going to go up, but the thought is, gosh, if one of us do end up there, I can get a calculator and I know what I'm worth, and I can figure out how long that can last. And for most people, there's only so much water in the well, right? And their state could be exhausted. So then you start getting concerned about it at that time. That's still a good time to do the asset protection trust, because let's take your average 60, 65-year-old person. They're basically healthy. I mean,
Sure.
we whine about our aches and pains and stuff like that. That's not long-term care stuff. You know what I mean? You're getting older, you've got some issues, but if we put the property in the trust at that point in time, statistically, we're still basically healthy. And statistically, we got about a 95 or better chance of clearing that 5 years. And that's the advantage there. Because when people say, when you put your property in this trust, you're triggering a 5-year penalty period. I say, that's right. They say, why would you do that intentionally? I said, well, that's exactly what we're doing. We're doing it intentionally.
Yeah.
When the question is, why would you intentionally trigger a penalty period? The answer is to get the clock started now, while we are still kind of healthy.
Sure.
If you wait till you're of advanced years and you got issues and you're getting ready to go into the nursing home or want to apply and you start giving stuff away, that's the worst thing you could do, because we'll never clear the 5 years at that point.
Right.
It's an absolute surety we won't.
Right.
But now we want to get the clock started now while we're basically in good health,
Yeah.
so that if something happens, long-term care is an if, dying's a when, of course, but long-term care is an if. Not everybody goes there. But if you go there, your assets have been postured in such a way that you're not
Sure.
going to be wiped out.
Absolutely.
And we do the best we can. So, a lot of times we protect 100%, and then there's times where there's something less than that. And the big difference is whether you're married or single, really.
Right.
When you're single, a whole lot of spousal impoverishment rules are no longer available to us, because there's no healthy spouse at home to keep from impoverishing.
Yeah.
So if you're married, there's a lot we can do and protect everything. If you're single, there's going to be some loss. I usually say it's in the neighborhood of a third. But if you put property in the trust, and with our asset protection property, some property's not in the trust. When you get to applying for care, all the assets in the trust are out of the equation.
Yeah.
So the only assets at risk is what's not in the trust. So if we lose a third, it's a third of the little bit that's out of the trust, not the big ticket items like the real estate that's in the trust. So again, even now we've just done 3 steps where we've actually mitigated, then mitigated it again, and then mitigated it again.
Yeah.
So, if you don't do anything, and you go, then it's a third of everything.
Right.
You got $500,000, and you lose a third, it's a big chunk of change. Now, saving 2/3 is probably the way to look at that, but if you got $500,000 and you got $400,000 in the trust, and it's been there for 60 months,
Right.
and you lose a third, now you lose a third of the countable assets, which is the $100,000 that's not in there. So now we've lost roughly $30,000 out of $500,000, which is a pretty good deal.
Yeah, that's a good deal.
If we can't do everything, we can't do everything, but we can do that. And then we would do one of those annuities where we have to pay for our care for a certain amount of time, and that's the cost. That's what the loss is. The cost it takes to pay through our own penalty period.
Right.
Now, if you're married, we don't have a penalty period. We just give it all to the spouse. I mean, that's an oversimplification, but essentially we transfer everything to spouse one way or another under the unlimited spousal transfer, and implement these spousal impoverishment rules, and we can protect everything, even if you're already in the home. Well, what we can't protect is if you're in the home, you're private paying. And we can't go back and save anything you private paid, but as soon as we
Okay.
get everything the way we need to and file the application, we can prevent the bleeding from there forward.
Sure.
So, anyway, it's if that sounds interesting to you, think about coming to the seminar.
Yeah, absolutely.
Now, I have a seminar that I recorded, and the girls are after me to re-record it. It's what we call an evergreen seminar. I don't make much reference to time or place. It just talks about what we do.
Okay.
And it does need to be a little bit updated. The prices need to be updated because the prices are modified a little bit. There's a few, I probably did it a year ago.
Yeah.
And it's just a few things I want to talk about more and a couple other things I want to not talk about.
Sure.
If you can't tell when I talk about stuff, I get a little off track sometimes. And they want to keep that out of the recorded seminar,
Yeah.
It's all of a sudden I break into a story, and when I'm trying to do something in a 60-minute seminar, it messes up the time.
Yeah.
I'm in the process of I was going to do it over the holidays, it just never happened, like everything else.
Well,
We'll get there.
it's something like that. I know from my own experience here. I need to record several new commercials, and I can't seem to get to it.
I know. It's one of those things you just got to finally just say, I'm going to get up an hour early tomorrow and get
Yeah.
it done.
Yeah.
Or stay up an hour late. Sometimes I just need some uninterrupted time. We stay very, very busy. And I say that because when people call me and they want to set up appointments, they're typically 2 weeks, sometimes 3 weeks out.
Yeah.
Because every hour of my day is doing something.
Yeah.
The gals in the office control my calendar. And I like that way. Most of the time I like it that way. Sometimes I don't like what they do, but they are doing it efficiently, really.
Yeah.
And so every hour of my day is structured. And if that's the case, I only have so many hours in a day, right? So it either fits or it doesn't. Now, actually, I've been thinking about hiring some people. I just haven't. I'm probably not going to hire another attorney, but I'm thinking about hiring some paralegal types. And actually, an opportunity presented itself where somebody sent me an email, and it was somebody going to UT Southern that was in like a paralegal curriculum.
Yeah.
With criminal justice or something like that, and they're looking to do an internship. And I said, if you want to do it with the area law that I practice in, I'd be interested. And so, that's going to start sometime here in the next week or two, and it might be interesting.
I bet, and that person, I think, will probably find it interesting.
And what I'm hoping is maybe after they do so many hours of the internship, then, if they're useful and it becomes successful, which I'm sure it's going to,
right?
I might offer them to stay on for a while as a paying gig, or if they might even be interested in doing something permanently.
Yeah.
But if not, when you hire somebody on, you have to teach them a lot of stuff.
Sure.
And we haven't done that for a while. We've been talking about it. We're going to give this a go and see what all's involved, and then you can find out the kind of things you can delegate to a new person and see if that works or not.
Sure.
We do a lot of deeds. Okay, we do it all the time. We do a trust. We always put the real estate in trust. So I've got a person that's my deed person, does all the deeds, but and they want to stay that way. But there's a lot of pre-work to get to the deeds to where we actually retitle them to the trust.
Yeah.
You got to find the deed. You got to get a copy of it. You got to get the book and page. You got to call the county and say, please email me a copy of that deed, and the tax card, stuff like that. That's kind of busy work on the deed. So
Sure.
That's kind of stuff somebody could do.
Well, that brings up a question for me, or a thought. When you're doing the deed and deeding the properties to the trust, which is what I'm assuming you're doing.
Yep.
I'm sure they have to do. Do they have to do somewhat of a title search to see if there are liens or assets or deed of trust on those properties? Or
We
something like
typically do not, because when you deed the trust to property to the trust, you're kind of deeding it to yourself. So if there's any encumbrances on a property, you
Okay.
should know about it. So we use a quitclaim deed almost exclusively.
that? Okay.
A general warranty deed, if a third person's buying your property, if I have a piece of property and you're the buyer, we're friends and all, but you would do a 30-year title search to see if there's any encumbrances on the title.
Yeah.
And that's usually when that's done. But if you're giving it to your child or putting it in your trust,
Yeah.
you know of any encumbrances that are on it, so no need to really do the title search. You certainly could do a warranty deed to a trust. We don't, because it's not. I don't think it's necessary. I've never had any. Only once or twice I can think of we did a warranty deed, and there was a reason for it. So.
Yeah, you may. This may not be something you want to do, but for people who don't know the difference between a warranty deed and a quitclaim deed, I do. But
I can give you the Reader's Digest version.
Reader's Digest.
We only got about 9 minutes left anyway. So, a warranty deed it's just what kind of, the word warranty is what's the key in there. It's a
Yeah.
warranty deed where the seller or the grantor is saying, I have proper ownership to sell this, okay?
Right.
And it's called the covenants of seasonship, okay?
Yeah.
I have trouble spelling that word every time. Fortunately, I don't have to spell it very often. But covenants of season, and it's saying, you know, I own this. I'm the proper person
Right.
to sell it. I'm going to guarantee to you and your heirs that this is good title that I'm selling you.
Right.
And typically, they do a 30-year title search to see if there's any encumbrances. So if you had a
Right.
mortgage, in Tennessee, it's called a deed of trust, which is a note.
Right.
That gets recorded. That would surface. If you ever, I don't know, got sued and didn't pay the judgment, and somebody slapped a lien on your property, that would be there.
Yeah.
And they find all that. And then that, in the process of buying and selling, that's a price negotiator. You know,
Sure.
You know, I bought a piece of property some years ago that was just in distress.
Yeah.
You know, and it's like, okay, I'm willing to pay $100,000 for this piece of property, but it's got $20,000 with a lien on it. So I'll
Right.
give you 80, and I'll pay the liens off, and I'm still only paying $100,000 for the property.
Right.
Which is, so it comes into the price. But if you have a quick claim deed, a good example of a quick claim deed is an as is. You ever buy a car and it's got a big sticker on the window that says as is.
Right.
You take it the way it is.
Yeah.
No warranties, no guarantees. You can drive, you can test drive it, you can look it over, you can do whatever you want. But once you buy it, it's yours. Don't come back to me and say, hey, I bought this and the windshield wipers don't work. You know, you get it as is. That's what a quick claim deed. It's really a reassignment of ownership. All the quick claim deed really does, it is an interest in real estate, so you need a deed. But all it really does is change the ownership from you to the trustee of your trust.
Yeah.
But as far as the property description, the meets and bounds description is identical. We don't make it bigger or smaller, you know, we don't change anything.
Right.
And we just change the ownership. And if you are putting a piece of property, like your home, into a trust, I mean, you know if there's any encumbrances on it.
Right.
Doing title search doesn't make anything that go away, it just identifies it.
Yeah.
And if you already know it, why, you know, title search costs a couple $100, and it takes a while.
So you're utilizing a quick claim deed to convey any interest that you have or ownership in it into the trust.
We use quick claim almost exclusively
Yeah.
in transferring to trust.
Oh, wow.
And I mean, and there's, you know, quick claim is a deed. It is a deed, you know.
Yeah.
It's just a different kind of deed.
Different kind.
I mean, you only have a few. You got quick claim deed, warranty deed, you have a special warranty deed.
Special warranty.
You know, other than that, I don't know of any other
I don't either.
instruments that are. Well, there are some.
I don't run into special warranty very much.
There's some weird ones out there, like monument of title, which is a probate. You know, it's not a probate action, but it's a way to transfer real estate.
Yes.
But it ends up in a deed. It ends up in a deed. And then there's affidavit of heirship, which is a way to transfer real estate in an intestate
Yes.
thing. And that, it is a deed, but the affidavit of heirship is the deed. It has all the meets and,
Sure.
it has the piece of property described in there. It's kind of
I do run into that.
sort of a weird deed, but it is technically a deed, so.
Yeah,
But,
absolutely.
yeah, that's, see, that started with, quick claim deed, yeah.
Yeah, interesting.
And it's quit, not quick, it's not Q-U-I-C-K, it's Q-U-I-T claim.
Quit.
Yeah,
Quit claim.
Yeah. And it's, you know, basically says everything I own and all the encumbrances on this, I give to you.
Yeah.
So when you give property to a child, you quit claim it to them, and they get the property and they get everything that comes with it.
Yeah.
Whether it's a note or no note at all,
Yeah.
it could, you know, and that's, I mean, that makes sense. It's
Yeah.
within the family.
Yeah. Yeah.
But if you've got a third party involved, I mean, it's always a good idea. You don't want a surprise. You know, if I
Nobody
buy
likes
it,
surprises
you find out you've got
In that arena.
there's an indebtedness somewhere down the pike. You know?
Yeah.
And that's what title insurance companies do. I mean, they will find all that. If there's something like that, they'll say, if you want to go forward with buy, we're going to carve out this exception, which is this creditor over here
Right.
that this property, they have a claim on this property.
Yeah.
So we're going to say, yeah, we'll guarantee title. We'll guarantee title except for that creditor because we've told you that they're out there and they have
Right.
a claim. So if they want to exercise their claim or foreclose or something, we're not guareeing it. They kind of carve that one out.
Yeah. Yeah.
And that's just what they do.
Or unless they remedy that.
Or they can pay it
Sure,
off. That's right.
sure.
I mean, sometimes it's just another person in the chain that has claim to the title.
Yeah.
Can't find them, can't get them to sign off their interest or something. They'll say, well, we'll guarantee it, but not for that person.
Right.
'Cause that could happen.
Yeah.
We don't want to be the ones paying for it.
We've run into that a time or two.
We've brought
can't
that.
find somebody.
We've brought it to your attention, and if we can't get it fixed,
Yeah.
we can't get it fixed.
Yeah. Absolutely.
Oh yeah. Some people have property and they call it heir land. Heir meaning H-E-I-R, right?
Yes.
And they just say, well, my heirs and assigns. I leave my property to, you know, my heirs and assigns. And within 1 or 2 generations, you have a lot of heirs. Like 30, 40, you know, it can be lots and lots. And you can't find all those people. And then when you start looking for them, you got 30 heirs, and you find 10 of them have passed away, and they've got 5 children each. And it can be a nightmare.
It can be. It can
It can
be.
be a lot of work to get that resolved.
It can
And then
be.
if you can't find them, you got to post it in the newspaper and say, listen, if you got a claim in this, you got so much time
Sure.
to express an interest or file a claim or object to what we're doing. Or,
Sure.
And that will hold up, but it's just not the cleanest way to do it. But there's got to be a legal methodology. You can't just, everything can't come to a grinding halt because you can't find somebody.
Yeah, that's
Because
right.
people are supposed to be findable. So if you're hiding, you know, we just go with the last known address or post something in the public record and say, you got 30 days to respond, and say,
Right.
well, they live in Arizona, you know, we find, some years later they find out, well, they live in Arizona, they didn't read the Lawrenceburg papers. Well, the law says that's considered notice if you do due diligence and you can't find
Sure.
where they are.
Sure.
Then you do it by publication, and that's considered adequate due process. So, if you don't like it, don't yell at me, I didn't make it up.
Didn't make the rules, but we're trying to live in them.
That's right.
That's right. That's right.
So we're coming down the wire here, so
Yeah.
I never can tell how close or off
Well,
your
we've
clock
got
is.
about 3 to 2.5 minutes.
That's what it looks like on your clock
Yeah.
too. So yeah, we have a seminar coming up a week from tomorrow.
Week from
the
tomorrow.
24th. That's right, right? Yeah.
Yeah.
Tomorrow's the 17th. Yeah,
That's right.
So the 24th, it's a Saturday. It's 10 o'clock in the morning. We call it Will's Trust in the Nursing Home, and that's what we talk about. It is going to be at the Star Theater on the square in Pulaski. It's on the south side, southeast corner. You can't miss the theater. So if you want to come to that, give us a call at Pierchoski State Law, Pierchoski Elder Law. The phone number is 931-363-7222. Tell us you're coming. We like to get a head count if you know. Or you can go online in my website, Estate Plan Stand, and I think you can sign up for the webinar the seminar that way. And again, here's what always happens. We inevitably have people that sign up that can't make it. Something comes up at the last minute, can't make it, and then we always have walk-ins. So walk-ins are welcome. We just like to have a good idea of
Yeah.
tables and chairs and something. And this one we got quite a few coming, so we're just gonna probably have just chairs out at the theater. Because we have the risers, it's hard to put tables up anymore
Sure.
while they're up. Anyway, but yeah, I mean, if you're interested in hearing what we have to say, come on and listen.
I know that people will find it interesting, no doubt, and informative, and a lot of good information to help you make a decision moving forward with all this.
You know, real quick, I heard my show on your station at some other time than Friday morning. I mean, I can't hear it when I'm here, but I was
Yeah.
listening to it. It seemed like it was later in the afternoon on the weekend or something. Is it playing again?
They may do it.
Okay.
I
I
actually
mean,
don't
if they
know.
were playing it again, so
Yeah.
I just forget when that was.
Yeah,
So
I think they do use it, especially maybe on the weekend, a time or two or whatever.
Okay.
It does happen. It sure
30
does.
seconds, right?
30 seconds or so. 363-7222, estateplanstand.com. That's a good way. And of course, we have got another one in the books, buddy.
We do.
All right.
And I will see you next Friday at 8 o'clock for the next episode of Bulletproof Estate Planning with your host, Estate Plan Stan.
All right, see
And
you
Jeff.
Perfect.